Question relating to the obligation to prosecute or extradite Belgium v. Senegal. The key parties involved in the case: African Union, Committee Against Torture, the International Court of Justice, Senegal, and Belgium. Hissène Habré, a former president of Chad, came into power 7th June 1982. During his reign, he allegedly committed several crimes against humanity and possibly genocide. Subsequently, after he was overthrown in December 1990, he sought political asylum in Senegal. In November 2000, a Belgian national of Chadian origin filed a civil party application with the Belgian investigating judge against Habré for serious violations of international humanitarian law, crimes of torture, and crimes of genocide. Accordingly, in 2005, Belgium requested Habré be extradited to Belgium to stand trial. Chambre d'accusation of the Dakar Court of Appeal rejected Belgium's jurisdiction over Habré. Further to that, Senegal referred the matter to the African Union. Additionally, the United Nations Committee Against Torture rendered also in May 2006 a decision in response to submission regarding the Habré case. He determined that Senegal had violated Article 5 of the Convention by failing to take necessary measure to establish jurisdiction over crimes under the Torture Convention. Moreover, the committee found Senegal in breach of its obligation to extradite or prosecute Habré under Article 7 of the Convention as well as under the rules of international law. The committee requested Senegal to report on measures taken to give effect to its recommendation within 90 days. Further to that, the African Union mandated Senegal to prosecute Habré on behalf of Africa in a decision of July 2006. Subsequently, the matter was taken to the ICJ. Senegal's argument. Senegal disputed the ICJ's jurisdiction on the grounds that no dispute existed between the parties regarding the interpretation of the Convention and Act of Torture. In that regard, Belgium cannot invoke the international responsibility of Senegal when none of the alleged victims of Habré were of Belgian nationality at the time when the acts were committed. Belgium's argument. Belgium responded that present jurisdiction is based in part on complainants who are Belgian nationals of Chadian origin. Belgium also claimed that the victims' nationalities are irrelevant because every state party to the Convention and Acts of Torture is entitled to insist that other state parties fulfill their obligations under the Convention. ICJ's response. In this regard, the ICJ agreed with Belgium, finding that state parties to the Convention have a common interest to ensure that acts of torture are prevented and that, if they do occur, their authors do not enjoy impunity. The court defined these obligations as obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. ICJ's ruling. Finally, the ICJ ruled that a nation is obligated to prosecute crimes under customary international law only to the extent that the crimes occurred after the nation obligated itself by treaty or convention to prosecute such crimes. Accordingly, the crimes Habré is being accused of are serious offenses that occurred past the date it ratified the Convention Against Torture. Therefore, by not trying Habré, Senegal breaches the convention. Resolution of the case and implications. On May 30th, 2016, the Extraordinary African Chambers in the Senegalese court system convicted Habré and sentenced him to life in prison for his role in torture, war crimes, and crimes against humanity. The case set a precedent in the international community because Habré later became the first former head of state to be convicted by the judicial system of a different nation for human rights abuses. The ICJ's judgment affirms that all 151 states parties to the CAT may insist on performance of obligation under the convention, even if the alleged torture occurred before the applicant states joined the convention, and even if the alleged torturer or victims have no connection with the applicant state. This holding therefore allows more states to act to ensure accountability worldwide for the acts of torture.